everyone. Welcome you all to joining today's class, Estate Planning. I'm Pauline Lam from Cotai Realty, your 2020 Co-Chair Education Committee. A few housekeeping tips. All participants will be muted, and should you have any questions, please enter it into the chat box. Speaker will answer you during the Q&A section. This meeting is being recorded and it will be available on our YouTube channel, West and Gabriel Valley Realtors. Jeff Huang, our committee member, will introduce you our speaker today. Now, Jeff, the floor is yours.
Thank you, Pauline. Good morning, everyone. I'm here to introduce our very special guest today, which is Benjamin Ali. He's a lawyer who's experienced in helping in estate planning, trust administration, probate, and business matters. To do all this, Benjamin leads the Ali Law team of attorneys and paralegals. Benjamin earned a Juris Doctor degree and tax cert from the University of Kansas School of Law. Benjamin was selected to serve on the University of Kansas Law Review, and it was a member of both the International Law Society and the Christian Legal Society. Benjamin has a wide variety of cultural diverse work experience. He was a lay leader in a Chinese church in the United States for over 2 decades. He taught English in China and speaks Mandarin Chinese as well. He was a proprietor in the restaurant industry. He also worked in Africa to rebuild an orphanage, worked in Malaysia to help crocodiles on the natural reserve, dug in Israel on an archaeological site, and led a humanitarian trips to Himalayas and Jamaica. Benjamin definitely has a lot of experience. So Benjamin's also a family man, raising his 2 children and wife, Anna, in Dyna Bar, California. I hope I got everything there. Thank you, Benjamin, for joining us.
Well, thank you for having me. It's a great pleasure to be here. I have a PowerPoint. Could I share that screen with you? Well, I thank you very much for the introduction. I want to talk this morning a little bit about, give you an introduction, and then also, it's okay, I'll do it. Give you an introduction, and then we want to talk generally about estate planning. And then we want to talk a little bit about the importance of, a couple of reasons why you might want to do some review of a trust, or you might want to help your clients to review a trust that have been a couple of hot topics. So first of all, thank you for the introduction. A little bit about me. I am a second career attorney. I was a minister before. I worked in a Chinese church. Actually, I was on staff for about eight years, and then I served as a lay leader in Alhambra for about another 12. But now my wife and I, we live in a Diamond Bar. My wife is American-born Chinese. If you're beginning to wonder why this Caucasian guy is working in a Chinese church, that was my connection. I also lived in Hong Kong for a while, which is why I can speak some Mandarin. Let's talk a little bit about estate planning. In general, what is estate planning? Estate planning is simply planning for situations where you might become incapacitated or you pass away. Those 2 situations. The main documents that you might have in a typical estate plan would consist of a living trust. You probably have heard of that. A pour-over will, a durable power of attorney, an advance healthcare directive, and then perhaps a certification of trust. The main part of a of the trust is the living trust, or the main part of the estate plan is the living trust. A living trust, how does it work? What is it? It's basically an agreement that you have with another person to manage your property if you become incapacitated or pass away. A trust is simply, think of it like a box. So whatever you put into the box gets distributed according to what the trust says. There's 3 main people in the trust. There's the creator of the box, and then there's the manager of the box. Some people call that the trustee. And then there's the person who can use what's actually in the box, which is the beneficiary. Now, imagine that you and your spouse, perhaps, are you and your spouse create a trust. And then, so you are the creators of that box. You are also, as long as you and your spouse are alive and well, you're the managers, you're the trustees, and you can use whatever's in the box for your purposes. Another thing that you might consider would be, what if both you and your spouse become incapacitated? Well, you're still the creators of the box, but you may not be able to manage the box anymore because you're incapacitated. So then someone else steps in. Let's say it's your brother or a trusted friend steps in to manage the trust for the benefit of you because you are still alive. The third situation would be if you've passed away. You're still the creator of the box, but now obviously you're not around, so you can't manage the box anymore. You can't be the trustee. So someone else steps in, your brother or trusted advisor, and then they manage it for the benefit of your beneficiaries. It could be your children, it could be a charity, whoever. Okay, so that's generally the way that a trust works. Other documents that we usually draft are a power of attorney, advanced healthcare directive, and then the pour-over wills. Often something significant for families is guardianship. In other words, we want to make sure that someone will step in to be the parental figure for a family if the parents are not around. We usually put those guardianship provisions into what's called a pour-over will. The pour-over will, so it handles the guardianship issues, but it also handles another issue, and that is if you are, imagine a situation where, let's say that we have the trust box, but someone has forgotten to put something into the trust box. In other words, let's say that there's a bank account out there that's only in your name. Let's say that, and you unexpectedly pass away. It's outside the box. We have the box over here and the bank account's over here. What happens to that bank account? Well, if we have a pour-over will, it automatically takes that bank account and it automatically pours it over into the trust that you're passing. It works as a great backup provision. There's a caveat to that, though. As long as whatever's left outside of the trust is less than $166,000, it's $166,250 in California, then we don't have to go to probate. This is a good opportunity to kind of talk about probate. What is probate? Probate is simply the court supervision process of the distribution of your assets. If you don't have, if you haven't planned anything, then the court is going to have to supervise that process. They're going to have to distribute your assets for you. What happens? Why is probate so bad? Well, number one, it's public. If you have nosy neighbors, family members that you don't necessarily like, everybody will be able to go down to the courthouse and see exactly what you had at your passing. Number two, it's quite expensive. If you have an estate that's about $1 million, which is not that hard to get around with a California estate, a California estate, it's pretty easy to have $1 million because your real estate is included. It will cost about between $23,000 to $48,000 to go through probate with $1 million estate. That's a far cry from doing an estate plan that will cost you probably somewhere between $3,000 to $4,000. Another document that's typically drafted is a power of attorney. We usually, the power of attorney works in a situation like this. Imagine that we've got the trust box. Something has been left outside of the trust box, but in this situation, your asset is outside, but you have not passed away, but you have become incapacitated. You are comatose at the hospital. So in that situation, what happens? How can someone access that bank The big one that this usually comes up with is an IRA or some sort of 401k or retirement account. Those retirement accounts can actually not be titled in the name of a trust. It cannot be put into the trust box. So it's going to be outside. So what happens if you have a 401k or an IRA and you get into a car accident and someone needs to take an early withdrawal from that IRA or needs to make changes to that IRA for your benefit because you're at the hospital? They can only do that. There's a couple of ways, but the easiest way is to do it as an agent on a durable power of attorney. Another document that's typically drafted is the Advanced Healthcare Directive, where you'll be naming someone to make healthcare decisions for you if you cannot make them for yourself. And then finally, a certification of trust, which is a shortened form of the trust document. Sometimes if you sell your house or you need to move property in and out of a trust, the escrow company will want a copy of the certification of trust, maybe the mortgage company. It's a shortened form that allows you to give those financial companies the information that they need without giving them the private information. So that's a general kind of description of estate planning and some of the importance of it. There's other things that are important that might be for your clients, and that is some people have business interests. So all of these things that we talked about with the family, as far as making sure that we plan for situations where if someone in the family becomes incapacitated or pass away, all of that also shifts over to this business situation. What happens to your business if you become incapacitated or pass away? And then we have similar types of structures for that type of planning as well. A couple of things though, that I want to kind of mention. I know that we're on a Zoom call, so it's really easy to kind of drift in and out. And so I want to kind of keep this short. But what are some reasons why we might want to consider reviewing, if you have an estate plan, reviewing it now, or talking to your clients about reviewing it, or even talking to your family members? The most obvious one is the hot topic that everyone talks about, that's all over the news, that is COVID-19. Never before have we seen a worldwide pandemic that has shown us how fragile we are as human beings. And the need for preparing has become ever so urgent for a lot of people. This is especially so for those at-risk populations, the elderly among us specifically. So I don't know if you have, all of us have parents here. We all have different relationships with our parents, but I want to take this opportunity to encourage you to talk to your parents about what they have in place. So how do you do that without kind of overstepping? How do you reach out to mom and dad in a way to talk to them about their finances, to talk to them about their maybe if they have any sort of estate plan in place? What do you do? What do you say? I would say you start out with several questions, and I can kind of give you some examples of those questions, but you do it over time. You do it over maybe a 6-month period, maybe a year, where you talk to them about different things. So question number 1 might be, Mom and Dad, how are you paying for your daily expenses? How do you pay for the utility bills? And are you writing it out of your checkbook? Are you doing an automatic payment? Kind of just becoming an interested person in their life. You also might ask them over time, do you have a financial advisor if they do have one, and maybe to get an introduction to that financial advisor. Maybe even, if you could, even sit in with a meeting. You might ask them, do they have any type of estate plan documents in place? You want to especially talk to them about that trust, especially if mom and dad have real property, a house. Because if they have a house that's worth more than $166,250, then they are going to have to they're going to have they're going to have some challenges. In other words, that property is going to end up in probate. And that's something that we want to avoid. You also might want to talk to them about perhaps something like what are their plans? Like, do they have any money in place for long-term care? This might be a difficult question, but you might be able to phrase it something like, have they thought about whether they want to live at home or they want to live in a nursing home, or if they want to live with family, who would they like to live with? Those types of things. Those are conversations we kind of need to delve into a little bit. This is ever so important, as I mentioned, because of the COVID-19, because anybody could get sick at any time. And once you're in the hospital, it becomes really, really difficult, especially because of COVID-19, because you can't, like, let's say that your relative gets COVID-19 and then they're in the hospital and they have to be behind closed doors. How are we going to sign any documents at that point? It becomes really, you can see the practical challenges of trying to get that done. So it's important to go ahead and plan right now. The last reason I think it's important to review your trust, or to kind of talk to your family members about it, is, so in December of 2019, there was a big change in the law, and it has kind of gotten overshadowed because of this whole pandemic, the COVID-19 pandemic. But in December of 2019, Congress signed into law the Secure Act. What did the Secure Act do? The Secure Act changed retirement plans in a very significant way. Before the Secure Act, you could give your IRA to someone who is you could, like, let's say that you gave your IRA, you passed away, and you made your spouse the beneficiary of that IRA. Well, at that point, your spouse could stretch out the payments over time and basically allow the money to grow at a greater rate and pay very, very little tax on that money, and allow there to be quite a bit of money for your spouse to have. Now, that's the same case now for spouses. But that is you could do before the Secure Act, you could do the same thing for your children. In other words, your children, if they were much younger than you, they could do the same thing and stretch out the payments all the way the rest of their life. They can't do that anymore. The new law is, if you were to give your retirement plan to your children, they have to withdraw that money in 10 years. And if they do not withdraw the money in 10 years, there's a 50% tax penalty. This is a game changer in the world of estate planning when we talk about retirement plan transactions. Because we have all of these trusts that have been drafted for the past 20 to 30 years that have very specific provisions in it about these retirement plan transactions. And oftentimes, those provisions need to be revised now that we have the Secure Act. Because if they are not revised and that money goes to your children through a trust, let's say that the trust is a beneficiary of the IRA, and then the money is to be distributed through the trust to your children, then in that situation, your children there might be requirements that say that your children could only get a little bit over time, and then in year 10, when everything has to be distributed, they're going to get a huge tax bill for the amount that is finally distributed to them. It's a big issue that needs to be, all of these trusts, if you have a trust that you drafted in the past even 5 years, you need to have your attorney look at it and perhaps even revise it, okay? I think I want to open it up to questions right now, because I think that will be more interactive since my PowerPoint is not working. So I'll go ahead and open it up to questions. How do I, can someone help me to do
Yeah.
the
Oh,
chat?
yes, of course. We've already gotten 2 questions right now. The first question is, can we have the PowerPoint presentation afterwards?
Absolutely.
Awesome. And then another one's from Mindy Ye. If I'm reading this correctly, agent of durable POA is valid after the person passed away.
That is incorrect, actually. A power of attorney is only valid as long as the person is alive. Once the person passes away, that power of attorney goes away. There's no power anymore.
Okay. So those are the 2 questions we have so far. Pauline Tang from your law office does have believes have a basic part of the presentation if we want to use that, but there are no other questions right now.
Okay, I'm sorry we had technical difficulties this morning. This is probably the best we can do for today.
So we did actually have one quick question that just jumped in, or actually make that 2. Can the creator reverse irrevocable living trust?
Okay, so the question is, so most trusts are revocable. In other words, you can amend them and you can change them. But let's say that someone creates an irrevocable trust, one that cannot be changed. Can you change an irrevocable trust? And the answer is yes. You have to go through the court to do it. The most common way to do it is you have to have all of the beneficiaries sign off and say that they are okay with the recommended revision. And if all the beneficiaries sign off and the creator of the trust signs off, then the court will amend the trust, the irrevocable trust. That's a great question.
The next question is, if I want to gift my assets to my children before I pass away, do you have any suggestions what I should do to avoid capital gains and other possible taxes?
Yeah, that's a great question. That's a common question. So if you give, let's say that you have a house and you were to give it to your children, it's important to realize that your basis for that house will transfer to your children. So if you purchased a house for $200,000, the house is now worth $500,000. If you were to sell the house, let's say that it's a rental property, so we don't get involved with the whole homeowner's exemption. Let's say it's a rental property. You purchased it at $200,000. Now it's worth $500,000. If you sold it, there would be $300,000 that would be taxable for capital gains. So it'd probably be about 15% of $300,000 would be your tax. If you give your children that rental property, the children take that $200,000 basis. So essentially, if they sell the house for $500,000, they also have to pay capital gain on the same amount that you would have had to pay capital gain on. Now, to make a contrast, let's say instead you put that rental property into a trust and you distribute it through the trust. What happens? If the property is distributed to your children at your passing, then the children get what's called a step up in basis. So whatever the value of the property was at your passing, then that is the new basis for the children. So for the children, let's say that you passed away and the property is worth $500,000. The property goes to the children at $500,000. They sell it for $500,000. They pay 0 on capital gains tax. That is my recommendation. Most often, especially for real property, you want to run it through a trust. The same thing for stocks, because the stocks have the same sort of issues with capital gain. Does that make sense?
That makes sense. Does the living trust protect assets in it after the owner died from the creditors?
Most often, I'm going to give you the general answer, and that is no. A revocable trust cannot protect the person who created the trust from that person's creditors. However, you can put provisions in it to prevent it from, you can create protections in the trust so that if your children have creditors, you can prevent those creditors from reaching the assets that you want to give to your children. There's a few sort of estate planning gymnastics sort of tools you can use to avoid creditors if it's your assets. One way that you could do it is in some situations, you could create an irrevocable trust where you would be gifting the asset to someone else through the instrument of a trust. And that sometimes works, and you can put provisions in the trust that will allow you to avoid capital gains in certain situations. There's all sorts of fun things you can do. But to answer the first question, living trust does not protect the creditors of the creator.
Okay, thank you. The next question is, does the Secure Act apply to federal government retirement plans
Yes.
and non-IRAs?
You mean 401ks? Yes. So most, if there's a specific type of retirement plan, if the person wants to email me later, I can tell them whether or not it applies. But my email address is bally@allylawgroup.com. That's bally@allylawgroup.com, and I can tell you if whichever specific retirement plan, if it actually applies to Secure Act.
Okay. Thank you, Benjamin. The next question is, when I set up a living trust, do I need to provide you all my assets and the value of my assets?
It's important for the attorney, I think, to know what assets you have. In other words, where are the bank accounts? Maybe what are the last 4 digits of that bank account number? In general, I think it's important to have an idea of how much is in those bank accounts. There's a couple of reasons for that. The first reason would be we're concerned about actually estate tax. So when does the estate tax, and what I mean by that is the tax that the government would apply to your estate if you were to pass away. For most of us, and I want to say 99% of us, we will not be impacted by the estate tax. Because currently, you can transfer tax-free at your passing for an individual like $11.5 million. Most of us are not at that level of $11.5 million. If you're a couple, it's over $22 million. But if you were to, let's say that, but if you are in that level, that's why an attorney would want to know, because if you're above that, if you're an individual and you're above that 11 million mark, then the attorney needs to maybe add some other strategies to deal with the estate tax issue, as well as the probate issues, what most attorneys are dealing with. The other issue is this. Many people pass away and nobody knows where their stuff is. In other words, they don't know where the bank account, especially now because so many people are having their statements sent to them via email, their bank statements. Whereas before, if someone were to pass away, you just get access to their mail. And then if there was a statement that came in, you knew, oh, this person has an account at Bank of America. But that's not the case anymore. If you don't have access to the person who passed away, their email, then you may not even know that they have money at Charles Schwab or anything else. So it's really hard to kind of track that down. So what I do is I try to have a list so that if the successor trustee does need to talk to me about certain things that the decedent had, I might be able to help them or point them in the right direction. Hopefully that's a practical answer to that question.
Okay. Thank you. Benjamin's email is already in the text chat, so go ahead and please check that to email him. So the next question is, what's the difference between revocable and irrevocable trust? Why is one better over the other?
So a revocable trust is one that can be changed by you, the creator of the trust. An irrevocable trust in general is one that cannot be changed by you, the creator of the trust. That's the general difference. Most people like a revocable trust because they have more control over the asset. They can, let's say that, for example, a common situation, a young family, husband and wife, they have young children who are under 5 years old. They create a trust for the benefit of their children. And then later on, maybe 15, 16 years later, they discover that one of their children has a drug addiction and that they need to amend the trust at that time. The revocable trust allows for that flexibility of life change and the unexpected to occur.
Good point. The next question would be, how much assets should one have to start considering setting up a trust?
Great question. The amount, so the question really is, who needs to have estate planning, right? And how much assets do you need to have? So most often the question is, everybody needs some estate planning. The question is, how much do you need? So do you need a trust? I would say if you have assets that are more than $166,250, that probate level amount, then you probably need to have a living trust. That's a good kind of ballpark amount. So most of us, if you have real property in California, you're already over that for sure.
Okay. Now the next question is the family trust different from the living trust?
I think, I'm guessing on what the person who asked this question, but my answer would probably be that they are the same thing. It's just a different name for the same thing. A family trust, some people call a living trust a family trust, and some people call a family trust a living trust.
Okay. The next one is more of a discussion point. Thank you, Mr. Ali. Please discuss points regarding what is the process once a family member passes away in regards to estate planning distribution. Okay.
Let's say, let me paint the easy picture. In other words, this person has planned, and then we'll paint the ugly picture of the one who did not plan, because I have to deal with them both often. Let's say that the person did very well. They've put all of their assets into their trust. Their trust is very clear. It's drafted well. All of the beneficiaries all get along with one another. Everybody's a happy family. In that situation, the person passes away. We go through the funeral. We have to, it usually takes about 3 or 4 weeks these days to get a death certificate. So we get the death certificate, and then we begin the distribution of the trust. Usually there is a notification that has to go out to all of the beneficiaries under law stating the person has passed away. We are going to start the distribution of the trust, and we move forward. If it's all easy assets, and what I mean by that is it's basically just money that's going to be distributed. You pay for the funeral, you pay for the final taxes, or you set aside a reserve to pay for the person's final taxes, and then you make the distribution. I've seen it done as quickly as 2 to 3 months at where everything's wrapped up. It's pretty fast. Now, if there are complications, what I mean by that is there's a house that has to be sold, there's cars that have to be sold, we have to clean out the house, which is most often something that has to happen. Then it takes a little bit longer to get those practical things done. So in general, that's the easy road. The hard road is somebody who hasn't planned, and then we end up in probate. So what that means is someone has to be appointed as the person that's in charge of the person's estate. And that person has to file for the authority to be given to them by the court. That person is usually called the personal representative in California courts. So that personal representative files. Before COVID-19, it used to take about 5 to 6 weeks to get a court hearing just to see if that person is going to have the authority to do it. Now, the courts are really overrun. Might be 2 or 3 months before that person actually gets a hearing just to see if they're going to get the authority or not. Once that person has the authority, then they have to file what's called letters testamentary. And that's the document that they will take to all these financial institutions or anybody else saying, hey, I'm the person in charge, and you can look to me to make sure that the person's debts are taken care of and that all the money's going to get distributed. That person will then have a 4-month period where they will begin to try to find out all the creditors, make sure that all the creditors are notified and possibly paid, and also try to gain control of all the properties. So if there's real property out there, if there's bank accounts, they'll send notice to all those financial institutions. And then they have to file what's called an inventory and appraisal, which is basically, this is a big list of everything that the person had. Then at that point, once that's filed, we file the distribution paperwork and a distribution petition. Then the court, we wait for another court hearing. The court will then approve or disapprove. We take care of the distribution, we take care of the final taxes, and then it's done. I say that, oh, you're like, oh, it's only about 4 or 5 months. Unfortunately, there's always problems. Nothing is ever straightforward. Most common, before COVID-19, a common probate would last at least a year, most likely 18 months. I had one probate that lasted 3 years because there was international assets. So you think about, let's say that you were to pass away and you've got young children. That's a long time for those kids to wait before any money would be provided for them. On top of that, let's say that the person did have young children and they're under 18, the court's not going to give those kids the money. Instead, we're going to have another court process on the side where someone's going to have to step forward and say, okay, I'm going to become guardian of the estate and guardian of the person for the children. I'm going to become parental figure. So you've got 2 different court situations now, and you've got the same sort of timelines with those types of things. So it's a great challenge for people who don't plan. Hopefully that answers the question.
No, thank you. That was a very thorough explanation. The next question is, do we need to record a living trust in order to be a valid document?
No. Some people will record the certification of trust, but most people don't even do that these days. A living trust is meant to be a private document. It doesn't have to be recorded with the county. Now, if you have deeds where you have transferred property into the living trust, then those deeds have to be recorded. They don't have to be, but it's better because it gives everyone notice that the trust owns the property.
Okay. Next question would be, what is the exemption after you have living trust? Oh, does that make sense? What is the exemption after you have a living trust?
A little confusing, but let me try to do my best and see what happens.
Thank you.
So the estate tax exemption does not change whether you have a living trust or not. Rather, most often the living trust is dealing with the probate issue, not necessarily the estate tax issue. There are provisions that you can put into the living trust that will help you to make the most of the estate tax exemption. But those are kind of 2 different situations. So hopefully that answers the question.
Okay. If it doesn't, kindly just please rephrase your question and we can ask them when it gets there. The next one is, can you explain how an A-B trust works? And then how about a Q-tip trust? Benjamin?
You might have froze out.
Okay.
Oh, okay.
Those are, so most advanced types of trusts, in general, let me kind of explain it. So an AB trust is simply a trust where if someone passes away, let's say that it's a couple. You have person A and you have person B. And person B then, that person's assets, or the 50% of the couple's assets, would then go to trust B for the benefit of the children. And then the surviving spouse would also have 50% of the assets. The surviving spouse can use their assets however way that they want to use it. The other one is sort of, it's not locked in, but it has more restrictions to that portion that would be set aside for the children. So it gets set aside. We call that the B trust, or the bypass trust is sometimes what it's called. And what happens is the surviving spouse can usually access this one over here that was for the person who passed away, can access it for situations of health, education, maintenance, or support, usually limited to those types of situations. And then that will basically get distributed to the kids someday. In other words, if surviving spouse gets married, surviving spouse can't take that money that's for the kids anymore. Surviving spouse can only take their half of the money into that new marriage. Does that make sense? So some people will do it in an effort to protect the assets from a future spouse for the person who's still living. Okay, so that's a typical AB trust. Yes, go ahead.
Oh, I was just going to say, what the Q-tip trust?
A Q-tip trust is very similar. It has a lot of similarities to it. You have the same sort of structure. There are limitations on how that, sometimes the Q-tip trust will allow for a little bit more flexibility on that part that is locked in for the kids. In other words, you can change the beneficiaries, but you can only change it among the children. So if you have 3 children, then you could, the survivor could then change a little bit to one or more of the children. It's really an advanced sort of structure that is not used as much, especially now because the exemption amount is so high. It's not really something that most of us really deal with on a day-to-day basis. Hello?
Oh, yeah. Okay. So, very good. Thank you for your advice on the Q-tip trust. Going to our next question, should stocks be added to trust? And what about IRAs? Should not, right?
Yeah. So in general, like I said before, if you are the owner of the IRA, in other words, you are the one who created the individual retirement account, or it comes through your work, it's a 401k, or if you work for a church or for the state, you got some sort of 457B or 403B or something like that. Those cannot be titled in the name of a trust. They have to stay in your individual name. So what I most often recommend for those retirement accounts is to make the surviving spouse the primary beneficiary, because the surviving spouse gets a lot of tax benefits that way, and then make the trust the contingent beneficiary, but then you make changes to the trust that allow for there to be discretion on the distributions. In other words, it's not going to require minimum distributions to the children. Usually that's the best way to structure it. But there has to be careful provisions in the trust with a retirement plan transaction. Now, what about just in general, like a brokerage account that has stocks in it? In those types of situations, you could, like, let's say you've got a Charles Schwab account and you've got a bunch of different equities and or different stocks and things in it. You can title that account in the name of the trust, and that's actually what I would recommend.
Okay. Okay. Thank you. Now, I think it was brushed. This question was brushed a little bit, but we wanted to get. So, from your experience, how frequent do you recommend someone to review their trust?
I used to say about every 10 to 15 years, but now with the two situations that I mentioned with COVID-19 and with the Secure Act, I think everybody needs to review. If you have a trust, it needs to be reviewed, at least for the Secure Act. But also, what happens a lot is people come into my office and they haven't looked at their trust, or maybe they don't kind of understand exactly what happened because their old attorney kind of just pushed them to the side or made them rush through the process. So they don't really understand how things work. And usually there are some sort of problems. In other words, maybe the person that you name to be the successor trustee on your trust or the manager on your trust, maybe you're just not really friends with them anymore, or this especially happens with people who nominate others as guardians. They kind of fall in and out of relationships, and maybe they're not very comfortable in handing off their children to these people anymore. So I would say everybody needs to review it if you haven't had it reviewed recently. And when I say recently, I mean like the last 3 or 4 months.
Wow. Yeah. Okay. Thank you. What do you think about digital software and setting up a trust through something like Quicken Willmaker as opposed to going through a lawyer? Is it just as valid?
Yes. So you have all of these different electronic devices or electronic ways of doing it, like LegalZoom or Willmaker or whatever, or the people that advertise on TV. Here's the challenge with it. You have to kind of know what you're doing. So like if I were to do it, because I draft trusts all the time, I would feel very comfortable in doing it because I would know exactly what they're trying to do. And I would actually even get in there and maybe try to fix some things about their documents that I was maybe uncomfortable with for one reason or another. The problem is you don't know what you don't know. And so what often happens with those types of companies is that you usually end up in my office anyway, and I usually have to fix it anyway. And you end up paying more because of the mess that it is at that point. I have to warn people, I have to fix a lot of these. But to answer your question, are they valid? Yes. And if you follow their instructions to a T, yes. I would say for families that don't have a lot of money, or maybe they especially don't have real property, they're just like living in apartments or something like that, it might be a valid option. You just have to be careful. I'm sorry, that's probably the best I can do for you.
Yeah, it does sound like it works from a generic template.
Yeah.
Who does the distribution, the trustee appointed or the attorney who drafts the trust?
The trustee is the person in charge of the distribution. The attorney who drafted the trust may or may not be involved in the trust distribution. So if an attorney drafts it, you don't necessarily have to go back to that same attorney to distribute the trust or to find. Basically, the attorney is just going to be there to kind of guide the process to make sure that the law is followed. So like helping you to get the notice out, helping you to send notice to different government entities and things. Some things that you may not be aware that you have to do, helping you to get those final taxes done. Yeah.
Okay, thank you. The next question is trust affecting income tax filing?
Do trusts impact income tax filing?
Yeah.
Okay, that's a real broad question. Let me kind of touch on a few things where a trust might have an impact on your income taxes. So in general, everybody has to pay income taxes, right? Every year, all of us have to file our 1040, our federal 1040, and then our California tax as well. So let's say situation number one. You have created a trust with you and your wife, or you and your husband, and the trust then, as long as you and your spouse are alive and well, you still file your same 1040. You still file the exact same taxes. There's no real change to your taxes. In other words, your income taxes. However, let's say the situation where both spouses pass away, and now the property, the trust, the money is held in a trust for the benefit of the children, and it's supposed to go on for the next 10 years. In that situation, the trust now is a separate entity. So the trust has to actually get a new tax ID number, and the trust has to pay income taxes every year then. And if the trust pays the income tax, it's usually at a higher percentage than an individual. So what people often do will be, they will just go ahead, the trustee will go ahead and distribute the income to the beneficiaries for that year, and let the beneficiaries pay the tax on that income on their individual tax returns, and then the trust will just keep the principal until whenever the distribution date is. That's usually the most common tactic. Hopefully that answers your question.
Now, the next question is, does the house and the trust have the primary residence tax benefit of $250,000 to $500,000 for a husband and wife?
Yeah, the homeowner's exemption, yes. It is, if you put a house into a trust, the homeowner's exemption still applies.
Okay. I think this is another version of that. If I put my house, which I live, into an irrevocable trust, can I still get the benefits of the $250K capital gain tax?
The answer is maybe. The reason is, if you have an irrevocable trust and you put that property into it, there has to be specific provisions in that trust that will allow for the trust to have grantor trust status. There's a specific section of the Internal Revenue Code, and those provisions have to be drafted into that. If it has those provisions, then yes, you can still have the homeowner's exemption. If it does not, then no.
Okay. If I do a 1031 exchange on one of my investment properties, which was listed in my living trust, do I need to update or report it?
Not necessarily, unless you want. Do you mean, do you need to update your trust? I think that's what they're asking. I don't think you necessarily need to update your trust unless you want to change the beneficiaries. You just have to make sure that you follow those 1031 exchange rules as far as getting a new property into that trust that's, similar or whatever. You guys know those rules better than I do, probably.
Okay, so we're at the 11:55 mark. So this will be getting down to our last questions. The next one is, there are a few states that allow for the creation of a dynasty trust. Which states will you recommend to go to for a dynasty trust?
Oh, that's a good question. I don't know if I know the answer off the top of my head for that. Yeah, I don't know exactly which states would be best. I would have to research that myself.
Okay. Okay, this next question should be the last question. If I have a irrevocable trust, can I change it to a revocable trust?
If you have an irrevocable trust, can you change it to an irrevocable trust? Most likely no. Because that property has been locked into that trust. you would have to go, if there was any chance of doing that, you'd have to do that through the court. And I think probably what you would have to do is have all the beneficiaries sign off that you want the property in the trust to be released to a new revocable trust that you would have drafted. I guess in theory, as long as all the beneficiaries say it's okay, I guess the court would allow it, but it would be up to the judge.
Okay. And then this is more of a logistics question. What's the best way to contact you in regards to this presentation or questions from this presentation?
You're happy, if you want to talk to me over the phone, just call our Irvine office, 888-663-9996. And then my office administrator, Pauline Tang, will set up a phone appointment with you, or a Zoom appointment, that's fine too. And I can talk to you about all your questions. You can also email Pauline at ptang, P-T-A-N-G, @allylawgroup.com. And she can set up an appointment, or and you can also meet at one of our offices if you would like. You can meet with me in person. We have an office in Pasadena. We have an office in Irvine. And then we also, before COVID-19, I was planning on opening an office in Diamond Bar, but that got put on the side. So it's still, but I can still meet people at the Diamond Bar location. It's just not an official office yet.
Thank you, Benjamin. That information Benjamin just gave us, the contact information, is added onto the group text. So please check that. And now this concludes today's Q&A section. Back to you, Pauline.
Thank you so much. Wow, is this a very fantastic section? I think this is a section with many, many questions, right? But we want to invite Mr. Ali, if your time is allowed, come back to do whatever you originally planned, those points to us. So I just asked Pauline. Pauline said we can schedule another one. We really expect you come back again. Now, I want to thank Mr. Ali, and thank you, Jeff, for your wonderful moderation for this section. On behalf of Western Gabriel Valley Realtors, we would like to thank Mr. Benjamin Ali for your wonderful and detailed presentation, and we benefit a lot today. And before the meeting adjourned, we would like to remind you tomorrow, 11 o'clock, check in at 10:50 for our Global Business Council present you this year, number 10 country, Peru. You may haven't been there. I have not been there yet. I want to join this meeting to learn what is Peru, what is the real estate market in Peru, in South America. That's Peru in South America. Mr. Benjamin, welcome you join together, Pauline also. And so next Tuesday, in another exciting section at morning, 9 a.m., we invite NAR, Dr. Lawrence Yun, and CAR, Senior Economics, Oscar Wei, to give us this year international real estate market and California real estate market update. Don't miss out those two great sections tomorrow and next Tuesday. We thank you again, Mr. Ali, and thank you, Jeff, and thank you everyone to join today's section. Thank you. We'll see you tomorrow, 11. Thank you.
Thank you very much.
Bye-bye.